Andrew came in and spoke to us, 2 weeks ago now, about business structure. So we've done some very basics on IT.
Okay.
It is in one of our standards, but I am by no means an expert. So we're bringing in the experts to help out where I think it needs a little bit more information.
Cool.
So just some background, these guys have all pitched, or most of them have pitched some sort of idea, or they're hoping to come up with an idea at some stage through the year. The plan of this program is to help them get that idea off the ground, or to upscale the idea if it's already going.
Okay.
So yeah, I will leave the floor. We've got half a class today, but as I said, we're going to record it. We've got our own YouTube channel where I'm putting all the recordings up. So if anyone ever does miss them, they can watch them at a later date.
Fantastic.
Wonderful. So I will leave.
Great.
Bring to you.
Sounds like you've already covered most of my topic, and that's a good news because I'm pretty hazy on the actual law. I'm not so bad on working out how to make money out of it. So make sure I'm writing the right thing. So I've just got to make sure that I cover off these things.
And then we'll see how good of a job that we've done with the basics.
This is probably one that nobody will talk to you about, but it's really important. The law of stickiness. There are any number of intellectual property rights. You know, we've got things like chip topographies, there's database rights in certain jurisdictions. But from a commercial point of view, these are the ones that are most likely to be the things that will touch the areas that you guys are kind of working on with your ideas. And what I can tell you is that no one of these things is going to be the right thing by itself. It's the way in which you layer these things that's going to work. So what I'm going to do is I'm going to talk through these ones here and then give you some examples, and then I'm going to talk about the law of stickiness. So let's start with some really easy ones. I've been doing intellectual property as part of what I do for about 30-something years. And so I'll talk about registered designs to start with, because I can knock them off really fast. Registered designs are a little bit outdated these days. The purpose of a registered design is it is it's an aesthetic it's an aesthetic design that is applied to an industrial thing. So it's not just art; it's art that's applied to something in an industrial manner. Whether it's the pattern on a Chuck's multi-cloth or whatever it is, it's applied to a product that's sold. And as you would suggest, as you can see, registered means you've got to go through a process of registration. I haven't done any registered designs in the whole time I've been doing kind of intellectual property. And the reason is that a lot of this stuff here is now covered by copyright in a lot of ways. And so most of the time people don't focus on registered designs. There are some values in them, but for the average person that's kind of coming up with an idea, the thought of kind of paying money to register something when you're probably going to get most of the protections that you want in terms of copyright, people kind of go, well, I'll take that money and I'll put it into developing my product further. So we can kind of knock off registered designs very quickly. Then let's deal with patents. Patents, and this is where you guys probably know more than I do, because you've probably been given the actual information around how long a patent lasts for. Yeah, roughly.
It's 50 years after the death of the...
That's copyright.
Okay.
I think it's 20 years. I just don't want to mislead you. 20 years from the date of registration. Like registered designs, patents are a process and they're a beast of registration. And the challenge that you have with patents is you've got to go through this process of registration in every country in which you want to kind of, take your product. Patents are really powerful and they're also very restrictive. The reason they're really powerful is that you don't even need to know about them to infringe them. So what happens is once you've decided that you've got something, you look at whether there is any value in registering a patent in relation to it. Now, patents aren't for everything and for everybody. They cost a lot of money to secure, and you have to go through a process country by country to register them. One of the good things about living in New Zealand is that we seem to sign up to pretty much every convention that is available. And so we have signed up to conventions that enable, if you get registration of a patent in New Zealand, then you can claim that as the point at which you're allowed to seek a registration in another jurisdiction. That's what they call kind of giving you some priority. And the problem with patents is it's the first to register that gets the protection. Probably one of the things I should have started with was talking about before I kind of dived into these things, so I'll come back and take a step back for a second. The whole idea behind intellectual property is that it is not personal property. So it's not something that you can lock up. It's not a car. It's not something that you can build a fence around like real property. It is, as intellectual property would say, it's a property of the intellect. And so the lawmakers way back in the day when they started to come up with this as an idea, they thought, well, we need to get this balance right between protecting something and actually stalling the development of society as a whole. And so they said, well, we've got to create this statutory monopoly. And so, there's a Trademarks Act, and a Registered Designs Act, and a Copyright Act, and a Patents Act. And so what they're trying to do is they have to balance giving enough incentive to somebody to create this thing and bring it forward, and not too much so that somebody says, well, I've got a monopoly in relation to that, so nobody can actually take that idea and go any further with it. And so you've got this kind of tension that sits there between the two of them. And the reason I wanted to go back and talk about that is patents is one of those real challenges, because you don't get a patent for everything. You get a limited period of time once you do get registration in relation to it. And you can't register patents for just anything. You can't register patents for an idea. So Einstein wouldn't be able to register a patent for E equals MC squared. If he, however, developed a machine that applied that idea, he can get it in relation to the application of that idea to that machine, that process, that whatever it is. But you don't get it for the idea itself. And so what happens when you want to go and register a patent is that you have to work with a patent attorney in relation to it, and you have to go through a process of saying, look, I've created something that is, this process that is so broad, and then the patent attorney works with you to try and define that down to what is the unique step that you have created, what is the thing that you have done that doesn't already exist. Because they don't want to give you a protection for something that everybody already knows, because then you're kind of going to slow down the advancement again. And so you've got to get that balance right. And so the registrar kind of goes through, and when you're working with a patent attorney, they will kind of start off with really broad description and then narrow. And you've got to basically tell everybody what is the innovation that you've come up with. What is it that you're doing? And the registrar will go through and go, no, that's too broad, that's known, that's too broad. And then they'll come down and they'll kind of work out the thing that you can get registration for. Once you get that registration, that's really powerful, because at that point, once it's registered, everybody is supposed to know what is on the register. And so if somebody else after that fact comes in and starts to do something that is similar or uses the process that is in your patent, then they're infringing your patent. And that creates a problem, because they aren't allowed to do that without breaching the Patents Act. And a really good example of it, and all of you will be too young to remember the BlackBerry, but the BlackBerry in its day was kind of the peak of innovation in terms of kind of mobile communication. And it was a Canadian company, and they registered a patent for the process by which information was updated using mobile to your handset, using email, so you could receive email. And everybody wanted a BlackBerry at the time. They went into the US, and at that point, somebody stuck their hand up and said, wait a minute, I've got the patent in the US for something that overlaps with the way that your technology works. You're not allowed to sell your stuff in the US without a license from me. And they ended up going to court in relation to it, and it cost BlackBerry several $100 million to be able to go and continue to sell this product in the US that they desperately wanted to sell and that everybody was demanding. And that's one of the things is kind of getting there first, getting the registration first, getting the description right first, and putting it into the market is a really powerful thing. One of the downsides to a patent, though, is it's only as good as the fact that it is not known already. And so if you guys are working with somebody and you think that you've got something that might be a patentable concept, you can't just tell anybody about it, because if you tell somebody about it, then it's in the public domain. And as soon as it's in the public domain, you can't get a patent in relation to it. Or you might actually spend a lot of money with a patent lawyer and get it, but the first thing that happens when somebody alleges a patent infringement is the other side go, first of all, I'm not infringing your patent, and second, you shouldn't have a patent for that in the first place. There is no innovative step in relation to that. There is, what you have done is already known. And so the argument that you then run is, anybody that owns a patent, it's a two-edged sword. Do I kind of sue on this and risk the fact that somebody's going to challenge it, and I've just wasted all this money, or do I kind of really try and close this down? And so that's the challenge with a patent. The idea is that if I go and register it in New Zealand, I register it in New Zealand, and then within a set period of time afterwards, if I can prove that, if I'm satisfied that this idea has got real legs, then I can start to go into other jurisdictions, and they will get the same date as the registration in New Zealand. So I've said there's two ways that typically when you start to work on patent litigation. One is you shouldn't have got it in the first place. The second is no, my thing is different to your thing. And that is the other problem with patents, is that you've got to tell everybody, you've got to tell the world what it is that you have done, what it is that you have come up with. And that's the deal that you have done. And in terms of getting that monopoly, is you've got to help advance the understanding of the of society. Is this is the innovative step that I've taken. And so if you kind of come up with a new COVID drug, and it's going to be compound A, B, C, and F, and somebody else comes up with a drug and they say, and you try and argue that they're infringing your patent, part of that is them saying, well, no, actually, mine is a combination of A, B, C, F, and something else. And it's the new thing, or swapping out F for something else. And then you have a debate about, well, was that the innovative step, or was that just kind of window dressing? And actually, the innovative step is already, is in the idea of combining these three components here. So it becomes this real battle, and it's quite a fine area to end up in, and that's why I don't do patents. Because it's really quite a specialised area. And typically when you're working with patent attorneys, you want to make sure that you've got the right patent attorney for what you are doing. There are chemical engineers and software engineers and mechanical engineers, and they basically work with you, depending on what your idea is, to capture the underlying understanding of what it is that you have. And then they try and describe that, and then they work with you to get that registered. So that's patents and registered designs. Again, patents have the same problem as registered designs, and the problem with them is that they cost for you to register, and you've got to go country by country to do that. And they're not cheap. They're not cheap to register. You can spend hundreds of thousands of dollars getting these registrations in place, and so for some people, they just go, well, and particularly in this day and age, where things are evolving so fast, one of the kind of things that has to go into your thinking is, am I actually going to get the return? Or will people have actually gone beyond where I am before I fully, realise the value out of this? I'm not saying that patents are a bad thing. I'm just saying that for some areas, particularly around some of the software areas, in New Zealand you can't actually get software patents. You can get a protection for the application of software as part of something else. So if you've got software, you won't get protection of the software itself, but you will get protection of the software as part of a washing machine process or as part of something else. That's what you get protection of. But with some of these high-tech areas, they are evolving so fast that the cost of getting it may actually not be realised by the time somebody has invented around you and taken it to the next step. So that's always one of the things that you have to think about as part of this process of, what protections do I look for? The next one is copyright. And copyright, everybody familiar with copyright? You get it of protection of musical, dramatic, artistic, literary work. The good news is this is the one that gives you protection of screen layout. This is the one that gives you protection of the pictures on that website. This is the one that gives you the protection of the underlying code. Because believe it or not, that is considered a literary work. And that's what you get protection of. That is right to the author plus 50. The problem with copyright is, or with the power of copyright is, that you don't actually need to do anything. In New Zealand, you don't need to register it. In other jurisdictions, there are benefits to registering it, but you don't need to register it in New Zealand to get copyright. So that's one of the powers of it. The problems with it is in the name itself. It protects you from somebody copying your work. So again, it doesn't protect the underlying idea. It doesn't protect the fact that, if you've looked at a screen and gone, this is a really cool idea, I'm going to take that, I'm going to sit down, I'm going to write my code, and I'm going to create something that is similar. It's not going to protect you from that sort of thing. What's going to protect you from that sort of thing is that when you come to something like, when you come to something like Microsoft Windows, it's the millions and millions of lines of code of having to sit there and write this over and create this yourself. That's going to create the problem. That plus the fact, why would somebody go and buy yours when there's something else that they could buy already in the market? So copyright gives you an element of protection. It will give you an element of protection in relation to the code. And people can't actually copy your product without infringing it and therefore infringing your copyright. So the way in which software works is obviously you kind of get a copy of the code. In the old days, you'd get a disk and it had a copy on it. You couldn't reproduce that copy on your PC without a license. You need a license to reproduce a copyright work, and that is where you need to kind of go down this path of getting those rights, entering into that agreement to get the rights to reproduce that thing, to use that thing in the manner that you plan to use it. So that's copyright, and then let's deal with confidential information. Confidential information is actually useful in its own way and in its own right. The problem with it is really limiting, because what you have to do is not tell anybody. You've got to keep it confidential. You've got to not share this with anybody, and that becomes really hard when you're trying to take this to market and you're trying to get people to invest. So what you have to do is you have to enter into non-disclosure agreements. And non-disclosure agreements actually work not only here but also up in your patents area, because you don't lose your ability to secure a patent for something just by telling somebody, as long as it doesn't enter the public domain. What you have to do is, as part of talking to somebody, you need to talk to them under obligations of confidentiality. In New Zealand, we don't have an act in relation to confidential information. Other jurisdictions, they do, there's Trade Secrets Acts and these sorts of things, and they try and draw a distinction between just pure confidential information and trade secrets being confidential information that has some kind of economic value and some kind of industrial application to it. But in New Zealand, you get protection basically under common law. So you kind of have to disclose it. You have to disclose it in a manner where somebody would ordinarily expect that it is confidential information, and then also that it's disclosed in a manner where people understand that they're supposed to keep it confidential. And so that's part of the problem with confidential information, is making sure that you set up all of the groundwork to make sure that people understand that this is something that should be protected. Yep.
Would it be normal for, if we went to like a pitch to pitch our idea, would it be normal for us to first get them to sign a non-disclosure agreement?
Yep. Yeah, it would, and and often this is one of the things I was going to talk about, but we can talk about it now. Seasoned investors, there's kind of a two-edged sword in relation to it. Seasoned investors want to know that you're treating your intellectual property well and protecting it well and protecting it sensibly. So in one sense, if they're going to chuck $1 million into your idea, they would take some comfort out of the fact that you are asking them to sign something, because then it's clear that you are doing the right thing to protect it, and you haven't told somebody else and therefore buggered up the ability to get a patent in relation to it.
Yeah.
But on the other hand, a lot of them kind of are investors in lots of things, and one of the things they don't want to find is often your non-disclosure agreements or your confidentiality agreements have within them, I'm going to tell you something, and you are not going to use that in any way other than to consider whether you want to invest. What happens if they already know that? And that's one of the things that they start to get concerned about is, if I already know that and I'm signing up to an agreement that says I'm not going to use that for any other purpose, does that mean I can't now invest in or carry on working with this other person that I'm already working with? And so you have that kind of conundrum of making sure that you've described it well enough that you give the protection, but not too broadly that you are going to cause those concerns for the people that you're working with. And there's no easy answer to that. Sometimes the best thing to do is, and I don't kind of recommend this necessarily because I'm an IT lawyer, is just make sure you're comfortable with the people that you're getting into business with, because there is really no substitute for that. The problem that you have with all intellectual property is it is to an extent what we call a shows in action. It's something that you can sue upon. And if you're starting up a business and looking for investment, the problem you have is you probably don't want to spend that money suing, because that's just going to cost you a bunch of cash. And the person that you're dealing with probably is better funded than you are, and litigation costs a lot of money. You won't get something in the High Court for less than about $100,000, and it can take years to get there. So that's one of the problems. And so one of the things that I would always recommend to people is make sure you kind of are comfortable with the people that you're doing business with. What are their reputations? Do background work. Understand what their reputation is. Are they a bit sharp? Do they have a reputation for doing this sort of thing? So that's one of the problems with intellectual property as a whole, is that you've got to basically be able to sue in relation to it. That's the only way to enforce it. Trademarks. The last one to talk about. Trademarks they can be either registered or they can be unregistered. Registered trademarks, you go through it. Well, if it's an unregistered trademark and somebody else actually has a right, uses a similar mark, you've got to basically go to court as part of it and say, look, there is this brand, their brand is very similar to my brand, people are likely to get confused, I have a reputation in my brand, and they're going to be writing off the reputation that I have. So there's a whole bunch of processes that you have to go through as part of your litigation. If you go and you get it registered, then you don't have to go through those hoops in the same way. You get registration in relation to it, and through that you are able to say, look, It's on the register, and somebody can't actually do this because it's on the register. It makes it simpler. There are a whole variety of different classes that you can register in. And that's so that you can actually have the same brand coexist, owned by different people in different areas. And so, a good example of that was Prince. Prince, in terms of ski gear and tennis rackets and that sort of thing, so sporting goods was registered. There was a well-established finance house in London that was also used the brand Prince. They were able to coexist because people were unlikely to ever think that the person that was running a finance company was also selling sporting goods. Some of the areas are...
Sorry, so I was just saying, so that means they were unregistered.
No, they were both registered. They both got registration, but they're registered in different classes.
Oh, right.
Okay? And there's a raft of classes, and it's kind of interesting to see what classes people register in. And if you think about some of the organisations that exist now, you can almost see some of their aspirations as where they want to go to next. I mean, if you look at Apple, the logical thing when they started out was kind of computers and that sort of thing, but clothing, TVs, phones, all of those things are areas that they've kind of registered in because that's where they wanted to go to next. And so sometimes it's quite interesting to see where they seek to register next. What's the other thing to talk about with trademarks? The other thing to talk about with trademarks is they can't be too descriptive. And so the challenge you have with a trademark is this conundrum between, do I do something that I have to explain what I'm doing, or do I do something that's quite descriptive? Because you can't end up with a monopoly in relation to, like Apple, if they were into fruit, would never have got registration at Apple. But Apple, as far as computers, you're not going to stop everybody else from talking about computers just by calling it Apple. Some of the things that you have is that sometimes you can be too successful with your brand and it actually becomes descriptive. Believe it or not, Windsurfer was a brand until it became too descriptive of what it did and was unable to continue registration. I do a lot of work with Microsoft, and they were at one stage, the council I was working with in New Zealand had this, I don't want to keep referring to Google, but at the same time, if I keep talking about Googling something, it may become a verb in itself, and therefore they lose the ability to have their brand. If you look at Xerox, they had to go through a whole process of re-educating the public about Xerox photocopies. No, this is not a Xerox copy, because that became synonymous with photocopying. So they had to try and go back and try and rework their brand to make sure they didn't lose it. Velcro is a brand. So there's a bunch of these that you have to think about and make sure you don't get them too descriptive, because people then just start using it for it, and you can lose the brand. The other way, of course, is, and the other challenge is that you do something that everybody kind of knows and you can't actually get the protection that they're looking for. The biggest and broadest protection is to get just the standard type font. If you can get the standard type font in the class, then you get all kind of representations in relation to it. But often what you've got is kind of a little bit too descriptive, and therefore you can't get protection of the type font. You get a stylized, so you get a logo protection rather than a kind of a word protection in relation to it. But that can be just the start of a process in terms of trying to get the broader protection. And I know that Herald at the beginning couldn't get protection of New Zealand Herald because, let's face it, Herald, Stars, Tribune, Bugles, they're all the same around the world, and so to try and claim New Zealand Herald was going to be a challenge. So they got the stylised logo to start with, but after a period of time they were able to establish that actually that became associated with them and they could start to get the broader protection. The great thing about trademarks is that they never expire. Well, they do expire, but you can continue to renew them. So you have to every couple of years refresh and your registration in relation to them, and continue to get protection in relation to them. So we've covered off all of these things, and as I said at the beginning, I just want to make sure that I'm not going to run out of time here. As I said at the beginning, there is no one of these things that's going to give you the absolutely right answer. It's about thinking about the way in which you can use them in the layers themselves. But with trademarks, they're actually an incredibly powerful tool because they stand for something. And you have to, as part of setting your business up, think about what does this stand for? What do I want people to think about when they buy my product? Because that's going to be part of why they come back and buy your product again and again and again. You know, so when I talk about Apple, people think about the clean lines, they think about the, you know, Apple have done an incredibly powerful thing. They've actually turned what can be a relatively mundane product into a luxury item through the way in which they position their brand. What do they think? You know, what do you think when you start to think about that? What do you think when you think about Rolls-Royce? You know, what do you think about when somebody says Cadbury to you? Do you start to think about the purple and the layering and all of that sort of stuff? This is the imagery, this is the branding that actually brings people back again and again. I'm not a big consumer of McDonald's, but every so often I get this kind of, yeah. And then I go and have a McDonald's and it's like, yeah, that's why I haven't had McDonald's in a while. But the brand in itself kind of brings you back again and again. Actually, when you're backpacking around Southeast Asia, you're guaranteed a clean toilet in McDonald's. And that was what drove us. That was our kind of high point at any part of our travels. What you have to figure out is what is the right mix for you. And if we look at a couple of different well-known products, you can start to understand about the way that these things aren't always that straightforward. The best one to think about is Coca-Cola. So if Coca-Cola had gone and registered their recipe in 1907 or whatever it was, they would have told everybody how to make Coke. And by 1927 or whatever it is, everybody could have made it from their recipe. So they decided they weren't going to do that. What they decided was they're going to keep it confidential. And so what they did was they had only a few people that knew the recipe for Coca-Cola. And they used to ship barrels of black liquid around the world at the beginning. What they focused on was their brand. And their brand is an incredibly powerful brand. You can kind of innately see it and feel it when you look at different things. I bought a bottle of water the other day and I kind of thought to myself, this feels familiar. And then I looked at the back and it was a Coca-Cola Schweppes. It was a Coca-Cola bottled water. And it was the shape of the bottle was the classic Coca-Cola shape. That's one of their brands. They continue to refresh their brand again and again and again. You know, Coke is life, Coke is it, Coke is... And if you go back and you look at Coca-Cola through history, they continue to refresh their brand and make it relevant for the current, you know, day and age. But also they have all of these sub-brands, but all of these sub-brands still work with the overarching brand. Then you look at an organisation like Sony. Now Sony, back in the day, created the Walkman. Now, this was the very first miniaturised kind of tape deck that you could listen to and carry around with you. And they registered patents in relation to it, and they branded the hell out of it. And everybody kind of associated the innovation with them. By the time everybody could figure out how to circumvent the patents and create their own thing, Sony was releasing version 2. And so why would you buy last year's product when you could buy this year's product? And so that was part of what they worked on, was this creativity, but they used patents to delay the process for others to kind of do the me too. And that leads me to the law of stickiness. Nothing you're going to find anywhere about this law in itself. It is just the fact that everybody wants to be in the market. And everybody wants to be where everybody else is. And everybody wants to own the largest share of the market. And so part of what you have to do is think about, how do I make it more compelling to stay with me than to go? How do I make it better for somebody to buy my product than to buy somebody else's product? And this is what everybody is working on now in terms of all of the incumbent service providers in the market. And when I talk about the service providers in the market, I'm talking about the likes of the Sparks of this world and the Genesis and the Vectors of this world. They know a lot, well, they have a lot of information about their customer, but they really have not exploited it the way that they could. And so what they do have is they have this pile of information that any startup, any challenger in the market would kill for right now. But once that's out in the market, then they don't need the Vectors of this world anymore, the Genesises of this world anymore, or the banks of this world. Or if they're not careful, they get regulated, like the UK banks have been regulated, so that they must open up their customer base so people can sell products to their customer base. So what you have to do is you have to try and slow down your competitors, but at the same time continue to deliver more and greater value to your competitors so they don't want to go somewhere else. And that is the law of stickiness. That is thinking about ways in which you can get into the market, deliver a product, create a following, and then make sure that following stays with you. And there's lots of examples of that we can kind of work our way through. When you think about it from the point of view of Trade Me, for example. I mean, let's be honest, Trade Me is not a massively innovative idea. I mean, it's eBay, but it's New Zealand's eBay. New Zealand is a third or fourth generation country, is the way I like to think about it. By the time those North American companies, those European companies decide that they're going to enter New Zealand, they've already entered the US, they've already entered Europe, they've already entered kind of Japan and Australia, and then they arrive in New Zealand. So by the time eBay kind of arrived in New Zealand, Trade Me had already set up. And they owned the market. And actually, they were proudly Kiwi. So there was this kind of stickiness there to start with. But on top of that, where are people going to want to sell a product? They're going to want to sell a product where there are buyers. And where are buyers going to be? They're going to be where the sellers are. And so the challenge that anybody coming into the market had was that they had to find a way to kind of break that down. And they haven't really successfully done that. The pressure point and the pain point for eBay customers in the States was the cost of selling in the market. And so you had Craigslist came up as a competitor to them, which was a different way of charging for the transaction that happened. But they haven't successfully found somebody, and I know if I worked with a client who tried to do the equivalent in New Zealand, and there just wasn't the demand in New Zealand for that. Because Trade Me continued to deliver enough innovation and enough reasons to stay in the market. And one of the things that they did was they delivered ratings and they delivered reputation. And so it became a little bit more of a trusted environment, a little bit more of a trusted market to operate in, because I couldn't take my Trade Me reputation into a new market. And so that became the challenge, was how do I kind of create something that is going to be equally as appealing to somebody that wants to sell a product or buy a product. I don't know whether this person's going to deliver it because I don't have a reputation in this marketplace. So it was a really powerful tool, but again, it was kind of a bit of stickiness. It was something that kind of you layered over the top to make sure that people remained. But it's not going to work by itself, as you can see with eBay and Craigslist. If there is enough of a pain point, people will find a different way of doing things. And that's, the reality. That is what, what Uber have done. That is what Netflix have done. They've looked at the base service and said, where is the pain point? Where is the friction? Where is the problem here that needs to be solved? And then they've delivered a solution to it. and then they've added onto it to make it more compelling to stay. And you can see with Uber in New Zealand that they are struggling, that others are struggling to get the kind of same reach that they have because they have more drivers, because they have a bigger profile, because they spend more in the market, and because actually sitting on top of all of that, they've just captured all of this information about the average New Zealander that uses them, and they are using that information to try and deliver greater value to them. But you can't always kind of count on all of that stuff because there is a bit of a backlash against Uber because of the amount that they keep. And others are starting to make some inroads there because of the amount that they keep. Whether it is, there was a major backlash with Uber Eats because of the fact that they kept so much of what the restaurant or the food outlet was kind of charging. And so people are starting to look for different ways, different places that they can buy their product. And so you've got the New Zealand offering of Deliver Easy and that are starting to make some inroads in relation to it. So it's all about making sure that when you build these things, you build them in a way that you continue to recognise the value of your customer so that they actually want to stay and they are compelled to stay. And actually there is a reason to stay. I worked with a client who set up one of the first kind of discount sites where you could buy a voucher so you get this this deal and you get it at a much discounted price. He sold out of it to one of the more established companies in New Zealand, but at the beginning, the very first deal he did when he came to me was it was kind of a movie and ice cream for $10 or something, and he pushed it into the market, and at the end of the first day, he had 10,000 subscribers, and that was the start. That was the thing that everything else started to build on, because now we started to understand the New Zealand public. He understood the people that were buying, he understood the purchasing habits, and that started to create that stickiness for him. How do I understand my client better to deliver better value? That was just a copy of a product overseas, but by the time they arrived here, they couldn't believe how much of a market penetration he had, the reach he had. And it was because he didn't stop at that one solution, he continued to build on it. How do I deliver better value? How do I deliver more to my client? So that other people can't kind of do the me too. And probably the best example of that is Apple, when you think about Apple and where they are. So I have 3 daughters, and as a result, my house is an Apple house. There is Apple everywhere, and I decided that I was going to try and break out of that. And I've discovered just how hard that is, because we have an Apple TV, and I can't FaceTime my daughters because I've got an Android phone. And so I think there's the WhatsApp and all of these things. My phone won't talk to the TV, my phone won't talk to their laptops. I can't kind of share information with them that quickly because there is an environment in which they exist, and Apple has built on that, and they continue to build on that. They are continuing to look at different ways to deliver greater value to everybody on the way through. And they will continue to be successful in that until there is a point where people go, actually, this is where the problem is. This is the friction point. This is why I want to go and do something else. And right now, the battleground is data and privacy. And that kind of is linked to the law of stickiness. Who owns, what rights do you have in relation to the information that is collected about them? And there is this battle going on at the moment in relation to different large tech companies as to the way in which they treat your information. And Apple have taken a view that they're going to kind of have your information, your personal information, as private information. And it doesn't matter what people ask of them, they're not going to share it. So they had an example in relation to this when the FBI turned up saying, we want information, we want you to crack this person's phone because we've got evidence that they've committed a crime, and not only that, they chose a crime that was pretty heinous so that they could kind of win the hearts and minds of the average American who would be outraged that their information was going to be hacked. And Apple just said, no, we can't do that. We have a contract in place. We can't and we won't do this. And they made a big PR campaign out of it. We will always respect your information. We'll always respect your rights in relation to your information. Doesn't matter who it is. It resulted in a change in legislation in the US around it. And what we have is we have a battle that's going on between the US, because most of these large tech companies are US based or they're Chinese based. They're US based or Chinese based, and then Europe has got a very, very large population. And their information is being used and being mined in lots of different ways. And so they created, I don't know whether I'm going off on a complete tangent here, is the General Data Protection Regulation, GDPR. And so what they did was they said, you can't take this information in this way anymore about European citizens. You've got to respect our rights in relation to it. You've got to tell us what we've got. You've got to update it. You've got to hand it back. You've got to give us a right to be forgotten. All of this stuff became this battleground around people's rights to their own information. But right at the heart of it is the data, which creates the law of stickiness. And so at the moment we have this kind of interesting challenge being kind of worked its way through with data. We are benefiting from it because the reality is that New Zealand's just not a big enough population to justify anybody changing changing the way that they do things. We're benefiting because we're coattailing on GDPR and the protections and the rights that are there. We aren't, if we said no, they'd just say, okay, that's fine. You just can't buy the product. You can't buy the service. And you can see a good example of that was Amazon. Australia population, 4-5 times ours? And they wanted to start charging GST on sales. And Amazon said, that's fine, we're going to build an Australian site for you and it's going to have a much smaller product line. I didn't care because actually the value that is being delivered out of Australia was a rounding error on their total product and their total kind of turnover. So if Australia's a rounding error, then New Zealand is not even really worth fighting about. And so that's the challenge that we have with the kind of the data and the privacy is that. And then actually the other side of it is our willingness to just kind of give it away and not really care about it. I did a bunch of work in relation to Netflix when they first set up here, and they called me before they set up and they said, so have you heard of us? And I said, yep, I've heard of you. He goes, so have you seen my product? And I said, no. And he goes, what? And I said, well, it's kind of a breach of copyright for me to be viewing this product in New Zealand. He goes, oh, yeah, okay, good point. But they're just so used to people going, I want to watch this, I want to do this, and finding a way around it. And if we said no in New Zealand, and Amazon or Netflix or whoever it is basically said, well, you can't have the product, then they'd find a way around it. You'd use your VPNs and whatever it is to mask your location so you didn't use access it. But privacy is a big battleground, and it's one of those things that any business that's setting up, you should, as part of thinking about what is my business model, you should think about this. If you think that what you're doing is incredibly innovative, like this client of mine who said, right, I'm going to, the movie and the ice cream for $10, massive amount of data. As soon as he had that data, he had a head start on everybody else in the market. think about it. Think about the way in which you can capitalize on it. But you will very, very quickly lose that, and you will lose that advantage if you don't respect your customer. If you don't respect the way in which they behave, you don't respect their rights, people will very quickly change the way in which they engage with you. And Facebook is probably the best example of that, with Cambridge Analytica and all of the ways in which they have kind of not respected the individual's personal rights to their privacy and to their own personal information. And they're still a massive organisation, but people have changed the way in which they engage with them. And a lot of people I know took Facebook off their phones because they suddenly realised that actually the app on their phone had shared personal information about them, where they were, what they were doing at that time. It picked up geolocation information that people didn't want. And so now people log into Facebook. They don't stay in Facebook in the same way that they used to. And that kind of probably ripped out a whole bunch of value out of their business model at the time. And so again, I come back to kind of looking at these things. When you start to think about your product, you start to think about the service that you're going to offer. Think about all of these things, but also think about the law of stickiness. Think about where is the friction, and how do I continue to deliver the next bit of value to my customer? And do I respect them in the right way so that I don't create the friction that causes them to go looking for an alternative product? That's me, Connor. With 5 minutes to spare. Do people have any questions?
Questions? Connor?
Yeah.
With patterns, like obviously there's going to be overlapping. Like someone would have invented the bicycle
Yep.
and then innovated on that.
Yep.
Does that mean future creations can't create a new pattern?
Yes, they can, but you've got to go back and look at what it is that you are claiming a patent in relation to. And this is one of those challenges, is that in entering into contracts, often what you have to think about is, if I grant you a license in relation to my product, and then you create an improvement on my product, nobody wants to buy my product without your improvement now. You start to capture the market to a certain extent. And so I now need to have a deal with you about how do I get your product, your rights, your improvement to my product. My product has at its core a bicycle. Now, if you get a patent for a 21 speed bicycle, you're still going to have to do some kind of deal with me if I own the bicycle. But I now have to do a deal with you because nobody wants just a 1 speed. And so you can get a patent for improvements as long as they don't kind of overlap completely with the underlying. So what you'd be working with your patent attorney is to try and describe what it is that you have done that is different to the underlying patent. Does that make sense? Yeah.
What comes after that 20 years? For the,
That's it.
Okay.
That's it. That's why Coca-Cola didn't want to register their recipe.
Yeah.
Because the downside to it is you have to tell your competitors how to compete.
Yeah.
You have to tell them what is that innovative step. And then they go, right, okay, well I think I can improve on that without infringing.
Okay.
So Coke doesn't have to list the ingredients that they have in their product.
They do on the back now, but they don't actually have to tell you how to make it. And they also don't have to tell you necessarily all of the ingredients, just the core ones.
KFC's the same, isn't it, with its herbs and spices?
Yeah, but
Isn't there one?
No, everybody knows that, don't they?
Well, no. You think you do, and everyone's like, oh, that tastes like KFC. But the actual recipe of those 11 herbs and spices, whatever it is, my understanding is there's only a couple of versions of it, and knowing the exact ratios, versus this amount of this spice versus a little bit more of it isn't going to change it. Not enough for the uneducated palate to know, but...
But also on top of that, is the whole store and the branding, and people go and buy KFC, or they go and buy McDonald's, or they go and buy Coke. They go looking for it because of what it evokes in them. Again, I come back to you know, kind of as soon as you start to talk about, you know, Cadbury and things like that, you start to think about what it is that they've worked really hard to evoke as an emotion in you. Well,
Oh, yeah, sorry, are patents always given to whoever registers first?
that's a really good question. You get, unless somebody can kind of show that your patent shouldn't have been given and should be revoked, if you get in first, then yes. It's not a, I had that idea before you did. It is actually about who got the registration first. Yeah.
So is there like a set cost that each person, or like within a patent or something, or does it vary?
It just varies. It varies on the basis of what it is that you're trying to claim as unique. And you know, and that's that inventive step that you have to try and describe. And you've got to do enough so that you get protection as broad as you're going to need it without telling your competitors too much about how to compete with you. And that's that kind of fine line. One of the powerful things about intellectual property, I've talked about kind of the downside, which is that you've got to be able to sue. The upside to it is the power is that it's infinitely divisible. As many ways as you can imagine, it can be divided. You know, you can set things up so that you have certain rights in New Zealand. You know, so if I develop a roofing product, a new roofing product, and I decide I'm going to license it, I could license it in different locations in New Zealand. I could license it on the basis that this person's going to have industrial rights and this person's going to have residential rights. I could basically decide in New Zealand I'm going to do it myself. In Australia I'm going to do it on a joint venture basis. I'm going to enter into a deal with somebody else. In the US I'm going to actually license somebody to do it because I just can't be bothered to get up there. And then you start to get into the terms of, you know, what rights do you have, how long do you have those rights for, what kind of information do you have to put it under my brand, all of these things. And all of these things need to be thought about as part of your whole process of kind of maximising the value. If I was going to license somebody my product into the States, I'd want them to use my brand. Why would I want them to do that? Yeah.
Brand recognition.
Yeah, absolutely. Absolutely. Because if they can take my product under their brand and then I cancel the license with them,
They can still use it.
they can carry on. They can find another person that's got a brand, like a product, and carry on as if nothing really has happened. What I want to do is have that brand recognition so that if I do terminate that license, I can go with somebody else and there's already demand. So there's lots of things that you've got to think about as part of kind of maximising the value of this. But the power is that it's as flexible as you can imagine it to be.
Any other questions on that? Okay, wonderful. I mean, I've taught the real basics of IP for a long time now, but learned a whole lot from that. Thank you, Simon. Will, you got something to say on our behalf?
Yeah, on behalf of the boys at Openground, I want to say a huge thanks for taking the time to come talk to us today. I know for a fact there's a lot of information there that we didn't know before, and we'll be looking to use that in our startups in the near future.